All right, well, looks like we're getting a ton of people joining right now, so I will start with some of the preliminaries while the rest of the remainder of the attendees join. We're very pleased to see as many of you joining as you can. We hope that all of you are sheltered and well and interested in what we're talking about here, and we wish you only continued health and security as we go through this tough time together. So today we're going to cover the Amazon neutral patent evaluation process, and we've got a really interesting set of people assembled here. So without further ado, let's just start introducing ourselves. So what we have a number of different hats worn here. Francois is definitely going to cover things from a corporate standpoint. Pamela is both a patent attorney and a trademark counsel, so she'll be covering the more brand central stuff. Aaron is in charge of our China practice, and we'll certainly be bringing that to it. And I'm chair of the analytics practice, but the people you should be listening to are Francois, Pamela, and Aaron on this, and I'm just here to keep things going. So. Let's have the panelists introduce themselves. Francois, can we begin with you and just give us a quick bio on yourself?
Hi, this is Francois here. I spent about 7 years at law firms and then have spent the bulk of my career since then in-house. I was the director of IP at Creative Labs and more recently the chief IP counsel at Plantronics. And so we've had a fair amount of experience with Amazon, and I hope I can provide some good insights.
Great. Pamela?
Yes, thanks, Mark. As Mark mentioned, I'm a registered patent attorney. I've been practicing about 30 years, but really spent about the last 25 of those years dedicated to U.S. and international trademark practice. So I really look forward to kind of approaching this topic from a brand perspective.
Thanks. Thanks, Pamela. Aaron?
Yeah, I am a U.S. patent attorney. I've been practicing for over 2 decades. About a decade, just over a decade of that was actually in Shanghai, China, doing patent prosecution and cross-border enforcement.
Oh, great. And myself, I'm ex-in-house as well. I was at Thomson Reuters for about 16 years, during which I handled a number of different roles across the Westlaw and Reuters platforms and financial services and IP. So my background is a little multi-practice across a lot of things. But at Strugman, I chair the analytics practice for the firm. So thanks for a lot. Just as a disclaimer, Amazon is not a client of ours. So all of our views are going to be from outside and gleaned from either our own practices or from public information. So let's move on to the next slide here. So in many ways, this is still, in my view, a pilot program. But so a lot of what we're going to present here are things that are gotten by experiential work between our clients and ourselves, as well as some of the other anecdotal stuff we've seen on the web. To my knowledge, Amazon has not announced this as a formal program beyond a pilot. And also, they're not really doing a lot in the analytics space and publishing much on that. So, going through the group, how prevalent is this program in each of your opinions? Say, Pam, how much have you heard or seen about this with your own clients?
Well, I've not seen a whole lot of use yet, but I actually believe that we're going to see kind of what we saw with brand registry, where it starts and then maybe makes some changes along the way as Amazon sees different experiences and gets feedback.
And Aaron?
Yeah, I think it's definitely a pilot program for now. There's not much published about it. I have had 3 clients though who've been targets of this, so it's definitely being used, but it's still in the pilot phases. There seem to be constant changes over time.
And Francois, does that align with your view, or do you have a different thought?
Yeah, no, that is does align with my view. As someone who was involved in enforcing on Amazon, it's always good to hear about new tools and give them a try.
Great. Well, and now, Aaron, since you've had some Chinese clients, so definitely want to hear your views on how they might vary from a U.S. client. But Aaron, if you could, let's have you take us through the process, if you could.
Sure. So this process is by invitation only. So if you are a patent owner and you are invited to take part, you fill out an Exhibit 1 request, which we can show on the next screen. And that includes information such as the patent, one specific claim of that patent for evaluation, and the Amazon Standard Identification Numbers, ASINs. Once that Exhibit 1 is sent to Amazon, Amazon sends that Exhibit 1 to sellers, and there can be more than one seller listed on that request, so it might go to several sellers. Then there are 3 weeks available for the sellers or seller to file Exhibit 2, which we also have a slide on.
Yep.
And during that time, what we've been trying to do, representing these Chinese sellers, is to negotiate with the patent owner to withdraw the request. So it is a really quick fuse. They say ITC is much faster than district court. I mean, this is really fast. It's only a 4-month process. So in these first 3 weeks, we try to negotiate the withdrawal and put forth non-infringement arguments, preferably, and also, while invalidity is not a defense for the patent, you can file, if you do find some prior art, you can mention the possibility of filing an IPR or ex parte re-exam of the patent if this patent owner does go through with this. So if it's not withdrawn, you do file that Exhibit 2, which identifies the seller and what Amazon Standard Identification Number products they're going to respond for. Then it's not clear how long, but I'm assuming within a week or two, Amazon will select a neutral evaluator who then sends instructions for payment. Those payments are due within 2 weeks. And we have a slide on that. We'll talk about that a little bit later. And then within 3 weeks is the deadline for the patent owner to submit arguments. And there are strict limits on page length, although exhibits and claim charts do not count to that page limit. Then there are 2 weeks for the seller to respond. Then optionally, the patent owner can reply to the seller within 1 week. And then there's supposed to be 2 weeks for the evaluator to make a decision. And assuming that the patent owner wins, the takedown of the seller products are supposed to occur within 2 weeks of that decision.
Yes, and then we've actually had a question happen as we're going through, so I'm going to try to take questions as they're relevant in the process that we're talking about them. So one of our listeners has asked, has this resulted in any DJ actions that we know of? And we have one near miss that we'll talk about a little later. But Aaron, do you know of anybody else that's filed the DJ action?
No, I haven't. I don't know of any cases.
Okay, Francois, do you have any thoughts on that? What Aaron has put forth there, or do you have other pathways you've worked with Amazon for some other patent issues?
Sure. Well, this does appeal to me, and I don't want to jump ahead to our benefits slide just yet. But this is something that if a client has a reasonable in-house department, this is something that they could do on their own. I mean, there's no requirement, as in a regular litigation, for you to have outside counsel. You may want to use outside counsel, but this is something you could do on your own. And my perspective of this is, with Amazon, you really need a multifaceted approach and try and use all of the tools that you have. And this is an additional tool. And one of the things, even try and think out of the box. Think of in terms of what other complaints can you make to Amazon that are not necessarily based on intellectual property rights. So, for example, compliance. Are the allegedly infringing devices compliant with marking for radio frequency compliance? Do they have radio frequency certificates for buy some of the allegedly infringing products and have your compliance people look at them. Food safety is another possibility if you're in the food industry. I was talking to the GC of Jelly Belly, and they had a problem with people buying the large packages and repackaging them into smaller packages, and they had success getting those taken down based on food safety considerations. So I think this is one of the weapons, and also maybe think outside the box a little bit as well.
Mm-hmm. Well, thank you. And I've also seen a number of people bringing product liability issues where people are reselling expired food and produce as well through the same system. But so here's kind of a toss-up question for the group here. What do you think Amazon's biggest motivations here in piloting this program? And anybody can jump in first here. But I mean, is this really them trying to avoid liability, to avoid legal costs, or give the appearance of a procedure that might work?
Well, I think that the online marketplaces have received a lot of criticism in the last few years that they're profiting off the sale of counterfeit goods, and there are some people who believe that these programs are just window dressing, and that participating in the program is going to give legitimacy to the window dressing. But I don't really think that is the case anymore. Amazon wants to have happy clients, and happy clients don't buy junk products. And so I think my sort of good belief is that Amazon is in good faith trying to address this problem.
Fantastic.
I agree. I think that Amazon now has experience, especially with brand registry. They've seen the ups and downs, and arguably this is a more complex procedure. And so I think having that experience has lent itself to Amazon opening the door for this type of program. But I agree with what Francois was saying. I think Amazon wants happy clients.
Great. All right. And in many ways, I think they have to make sure that they aren't being somehow helping of patent infringement as well, because even though that the structure and rules of getting yourself into a kind of a contributory infringement thing are quite complex. Just the number of transactions, the number of things getting knocked off, the number of I work a fair amount on the trademark side, and the number of identical goods under different brand names happening on Amazon is literally legendary. So I think that they have to have some process in place to update and remove things that are infringing, rather than wait for a multi-year patent litigation to go through. Can a single request cover more than one seller, guys and gals?
Yes, you can list multiple sellers, although when it's time for the actual evaluation, I believe you can only have currently 4 opted-in sellers. So while you can list more than 4, once it comes to the evaluation, max is 4 sellers.
Okay, and who's probably the most ideal users? I mean, Francois kind of brought forth the in-house corporate department that could do these things themselves and minimize their legal fees. But are they the ideal user of this process, or who do you think is the best suited for this process?
Well, I think for me, it's really going to be something for which infringement is reasonably easily determined from an evaluation of the product. If your IP is buried in the functioning of a processor, it's going to be impossible to use. So probably the more I hate to use the term simpler, but something that for which infringement can be easily established.
Yeah, I mean, I think that would be the ideal user. I'm wondering though, because in my experience, a lot of Chinese sellers don't respond in time. So it might be possible to target even electronics and so on that are actually being sold on Amazon by foreign sellers in the expectation that they won't respond and that therefore their products will be removed from Amazon.
So a simple way to remove regardless of the the quality of your infringement claim.
Right, regardless of the merit of your claim.
Okay. Well, let's move on to some of the exhibits now. And Aaron, if you wouldn't mind, just kind of let's walk us through, how simple this is when it's sent out. So.
Yeah. So the exhibit 1, this is what the patent owner supplies, and it's a very simple form. I think some of the key things to know is there's a utility patent number you have to put down, and for evaluation, you can only list one patent claim. And since invalidity is not a defense, you want to select your broadest claim. Then your Amazon standard identification numbers. So in this case that I handled, there were about 50 on here, but now that's been reduced to 20, it looks like, in the more recent information we've seen. And of course, your signature at the bottom.
Do you put any of your argument in this, or does that come later?
No, just this information, no arguments.
Okay. And then here's exhibit 2.
Mm-hmm. So certainly, your name, address, then your representative, which could be the seller or an attorney, email address, and then importantly, the Amazon standard identification numbers of the products you're going to participate in. So if there are products you feel probably are infringing, but others are not, you only want to list the ones that you feel you have good arguments for. In addition, because it can be multiple sellers, not your products. So you want to make sure you only list your own products for in this area.
So there's no third party or reseller rights allowed here?
No. Although, I mean, certainly depending on who's targeted, there can be, I guess, an indemnification claim against the manufacturer. You may then hire an attorney to represent them. Now you just put in the authorized representative information. Great.
So let's switch gears to fees right now. So to the degree, I'll just stand back and let you guys speak respect to this because this is your world. So Aaron, if you'd like to start.
Sure. So for the patent owner, it's the $4,000 per request per exhibit 1, and the seller, each seller, it's also $4,000 per request. So from the patent owner perspective, it's a flat fee for one patent up to 20 products and up to 4 opted-in sellers. For the seller, it's a flat fee regardless of the number of products they're defending. So I think this does advantage the patent owner because they're getting $4,000 and getting up to 4 sellers for that one flat fee.
And just to clarify what's meant by opted-in sellers, you can include more than that in your request. So if you include 20 and 8 of them respond, then your 4,000 is for the first 4, but you do have the option then of saying, okay, I'll pay another 4,000 and to add additional groups of 4.
Mm-hmm. Right. And then in terms of, go ahead.
No, just go ahead.
Okay, so in terms of disposition of fees, the max payment to the evaluator is $4,000. So if there's an absolute winner, that winner gets the $4,000 refunded. And then the evaluator gets $4,000 from the patent owner if the patent owner loses, or divided evenly among the sellers found to infringe. If there's a partial win, there's $2,000 refunded to the patent owner, a full refund to sellers found not to infringe, and the evaluator gets a balance of $2,000 divided evenly among the sellers of the infringing products. And then the balance goes to an Amazon Smile charity chosen by the patent owner.
So how well do you get to know the evaluator in these things? I mean, is the evaluator given a name, or is this, you know, a blind, neutral, anonymous process?
Yeah, I don't know. Personally, I've been able to get these taken down or withdrawn even before we've done the payments, before we've had to file the Exhibit 2. So I don't have too much experience with the actual who the evaluator is.
Yeah, I don't. I'm not sure if they're well described. There's virtually no literature out there on who these evaluators are. You know, I see a fair amount of advertisements, both on Google and whatnot, doing ad buys trying to find sellers who receive these notices. But again, it's a little murky as to who all are the evaluators and what their qualities are. So let's walk into the next slide here. So this is essentially a letter from Amazon to a seller. I don't know if there's anybody who wants to chat through this or not, but just a standard demand letter. All right, and let's move on to the benefits as well here. So let's all put our different patent hats on here, and let's talk about the various benefits you see to the sellers and the buyers here. So Francois, do you want to kick us off?
Sure. Well, one of the things that appeals to me is the speed. As someone who tends to represent the patent owners, is the speed to decision. I mean, 4 months is really great. Also, the cost of the $4,000 fixed fee. That is only when the neutral evaluator is selected. So that's only after one of the sellers has responded and opted in, and the neutral evaluator is chosen. So as Aaron mentioned, the possibility is that the sellers might not respond at all. So you've got a free takedown there. This is also confidential. This is a form of early neutral evaluation that is an alternative dispute resolution that is well known, and the agreement that you sign, parties sign, specifically states that the participation is confidential, and that any documents that have been exchanged are confidential, and also that participants agree not to seek discovery from participants regarding the evaluation in any litigation, arbitration, or agency proceeding.
Pam, do you have a thought?
Yeah, well, the thing that really caught me on the program is just that I think we all deal with so many clients who simply cannot afford patent litigation. And so for me, the cost was really what I think is one of the biggest benefits. I mean, it really opens up this recourse to smaller businesses or folks who wouldn't have it otherwise. I also liked the fact, and I think you may get argument that this is also a negative, but I actually like the fact that it wasn't binding, so that if the patent owner receives a negative decision, it doesn't necessarily stand in the way of them being able to seek recourse through the courts.
And Aaron?
Yeah, from a Chinese perspective, from a seller, I think it's actually pretty interesting, because you can name, I guess, an unlimited amount of sellers in the Exhibit 1, but most likely a lot are just not going to respond. So if you're the sole seller, say out of 20 sellers that have responded and you win, while the others just defaulted, you end up with a duopoly with the patent owner on Amazon without investing that cost in getting the patent and enforcing it.
So to some degree, there's actually a patent owner bias going on, because if there's no penalty for other than waiting for someone to assert and pay their fee backwards. There's no real penalty for a patent owner to be overly aggressive.
Definitely not.
And okay, so let's, I've got a question coming here, so I feel that let's cover the backside here and talk about the negatives. Well, you guys are can you give some color to these negatives? Francois, do you want to start us off here while I'm responding to getting the question up here?
Yeah, so you are permitted to make arguments in your exhibits. I think the page limits are 20 double-spaced pages for the two submissions made by the patent owner, and the respondent may use 15 double-spaced pages, and claim charts and exhibits are not counted against the page limits. In terms of the admissibility in any subsequent litigation, as I mentioned previously, this is a settlement under early neutral evaluation rules that will not result in the arguments that you make being made admissible in any other proceeding.
Mm-hmm. Em, do you have any thoughts?
The negatives, again, I think many times the positives can also be seen as a negatives. But for me, when I went through and kind of looked at the background of this, the thing that jumped off for me was just that, patent litigation is very expensive, and one of the reasons is because it's quite complex. And so we have, we're looking at a process that really doesn't address the typical complexities that you would be addressing in a patent infringement action. The fact that there's no expert witnesses, there's no precedent. I think that there are some things that are going to cause trouble with this, and I think lend to the, we talk about this patent owner bias, I think really slant it heavily that direction. But again, with the brand registry, we've seen changes, and I think that Amazon will be looking for things to change and possibly improve, as time goes on and they see what some of the results are.
And Aaron?
Yeah, so from my perspective, or I should say from a Chinese seller perspective, the issue I think is language and speed. Because this is all taking place in English, some of these foreign sellers may not understand it or may not respond promptly. And one of the things I'd like to see change is to give more time for foreign sellers to file that exhibit to. But that also gives I think the patent owner bias to target foreign clients, or foreign sellers, I should say, because of that language barrier.
Yeah, and I think that's why you brought up the fact that the design patents aren't covered. So, is that an important miss on the side of Amazon?
Well, ever since Apple released the iPod, industrial design has become one of the most important factors for many companies. And having come from companies that both relied on the appearance of their products as one of the selling points, no design patent enforcement is a negative for me. Amazon does, if you can make a complaint to Amazon on the basis of a design, but the results are very inconsistent, and sometimes even for something that is clearly design patent infringement, you get a sort of form rejection without any real reason, or reasons that are taken from utility patents. Things like saying, well, patents are often held invalid, and those kinds of things. So it's from a consistency perspective, I would really like to see design patents included in this program. perhaps even at a lower cost, because it's a much easier infringement assessment.
Mm-hmm. Well, a question coming in from the audience here: does a loss for the patent owner in any way clear the way for others in the future to come into that? And I'm going to interpret that as a loss of the patent owner clear the way for any other sellers. So, is there any stare decisis in this process? Anybody jump on in if you'd like to comment to that?
Well, the outcome is confidential, I believe,
Yes.
and I guess perhaps word of mouth might clear the way for others, but this is not going to be something that is visible.
Indeed.
Right.
Yeah.
And also, I should say, you might be able, as a patent owner, to refile because you're only evaluating a single claim. So if you fail on one claim of your patent and you have multiple independent claims, perhaps you could refile using a different claim.
So yeah, there's a lot of power in the hands of the patent owner. In this case. So all right, well let's move on to some of the things that are just that are cost risks and stuff that happen outside of the practice of the actual evaluation itself. So Francois, are there any thoughts to this that other costs and things that are not really touted in this process that you want to make us aware of?
Well, I think for many, you really want to make a good case, and for a small company, if they don't have in-house patent attorneys, it is going to involve, or highly recommend involving a registered patent practitioner to prepare the documents. So there could easily be an extra, $10,000 to $15,000 of legal fees that are incurred.
And the same would probably be true of the seller as well. If you're trying to keep your patent
right
alive, you probably should have a patent attorney on the backside. To the aspect that Amazon is kind of the one picking the evaluators here. I think there's a significant risk in whether or not the evaluator really knows what they're doing, and that sort of behavior. I spend a lot of time looking online and trying to figure out, anyone holding themselves out as an Amazon evaluator, and frankly, very, very few did. Pam and Aaron, do you have any other thoughts on additional risks and whatnot that we haven't covered already?
Well, I'll actually chime in on what you were just saying. I had the same experience. I was looking for any literature talking about or addressing how Amazon actually chooses the evaluator. And I was finding nothing, at least at this point. And so I think that may be something that, when we talk about maybe things that change with this program over time, I think that's probably going to be one area that they're really going to have to address. The evaluator, to me, is going to need to be skilled in the particular art. And I'm not, now maybe Amazon, uses that as part of their decision-making on choosing the evaluator, but I just haven't seen anything that indicates that is actually taken into account.
Yeah, to me, that's probably the biggest risk in this, is that you get somebody who's not skilled. I mean, there is some bias in the sense that the patent owner can be overly aggressive and suffer nothing for being overly aggressive, but at the point you actually get into an argument with an evaluator, I would imagine the skill of the evaluator has to be brought into question. And the aspect that there's no appeal, I think, also is a problem at this point. We, as I mentioned, we have a near miss case where someone was actually taken down from Amazon not using this process. And we'll talk a little more about that later. But taking essentially a DJ to the street versus the end of being satisfied with this appeal. So let's talk a little bit about the demographic of who's representing sellers and whatnot in this. And this is a slide that I did just trying to figure out who's in the playground here. And there aren't a ton of people. I mean, some of the large law firms, you might have 1 or 2 attorneys engaged in. There might be a piece written by a senior person in the larger firms. But it appears that the greatest activity is down in 1 and 2 person firms that are buying Google ads and having essentially virtual offices. There's a fair number of virtual office law firms that hold themselves out as being sellers law firms that help them get their product back onto Amazon as well. And so again, there's still this kind of missing cadre of people that you can say, oh, these people are skilled in this area. They're all very small law firms that seem to be working in this area at this point. Anybody else on any of the panelists here have any thoughts around that? And another thing I wonder is, that this might be somewhat akin to the IP Accelerator program that Amazon has kind of in its own right on the trademark side. So, for those who don't know what this is, it's a program that Amazon has that has, I believe, 11 law firms qualified to help them on trademark. And Pam, you can certainly jump in and describe that more.
Sure. Yeah, I mean, it's a program that where Amazon connects you basically to firms that would help you secure trademark registration, which under brand registry is a requirement. The interesting thing about the IP Accelerator, and I'm interested over time to see how this will apply to the patent side of things, is that if you use one of the law firms under IP Accelerator to file your trademark application, you do not actually have to have the registration in order to participate in brand registry. So Amazon is, in this instance, driving folks to specific firms they get a benefit, in other words, for using those firms to actually file their application. I think we're going to see, I saw a lot of commentary about people are people going to start filing marks that are maybe merely descriptive or generic and taking advantage of the IP Accelerator? So time will tell. I mean, I think that, we all are at this point trusting the firms and the attorneys that are working in that program, that they wouldn't be, filing for things or marks or terms that are generic. So we'll see, but I know that that's certainly a concern of that program. So I'm interested to see if that same type of thing applies over time to the patent program.
Great. And well, I still got you there. As long as I've got you, Pam, here, let's jump over, just kind of quickly run over the other projects that Amazon's doing with IP programs.
Oh, sure. The brand registry, and this is one that in its current form it was in 2017 really that was updated. And so I think you have a lot of brand owners that are familiar with this particular program. It's in a nutshell, is a program. If you have a federal registration, not a supplemental, but on the principal register, if you have a registration, you can enroll your brand in this registry. And it basically gives you more control over your brand. I think the big difference between this and the patent program is that while I think a lot of folks will look at the brand registry as a means to address counterfeiters and infringements, a large piece of the program is directed to ways to manage your brand. It just gives you a more holistic view of your brand's performance overall. And so I think that's one of the big things with brand registry. I have personally gotten a lot of questions from clients about, again, the supplemental registration, whether that's good enough. I know there's a lot of clients concerned about the timing at the USPTO and how long is it going to take to get the registration. And I think that will be continue, in that way. Folks concerned about timing. I will say on the IP Accelerator that we just talked about, the one thing that really struck me was that under the brand registry, and again, these questions I'm getting about the supplemental registration, you have to have a principal registration, yet under IP Accelerator, you do not need to even have a registration at all. Pending application gets you access to brand registry. So I think that there's going to be quite a bit of criticism over time for that. And again, the IP Accelerator program is directed to getting the registration, or getting the filing, I should say. Project Zero is an invitation-only program as well, so it's similar to the patent program, and it gives you a number of things. But I mean, the two top things that you get under this program is there's a self-service takedown process. You do have to have a history with Amazon, a history of very successful takedowns in prior years. I think the figure is you have to have a 90% success rate on that. And then, you have product serialization also that you get from this. Now, you can get the serialization from other programs too, but that is one of the benefits to Project Zero. As an aside, going back to brand registry, there's no charge for that. So I think that what we're seeing is, most clients undertaking that process themselves. I know that there are other companies that are kind of helping folks navigate that process, but from the standpoint of securing counsel, what we're seeing is really clients coming to us to help secure registrations and things like that, but not actually help with applying to be on the registry. So that's been some interesting things that have come up through these.
Another aspect of Project Zero is that there is an automated takedown aspect to that as well, that Amazon can kind of learn based on a number of different factors what seem to be infringing of your IP, and can do takedowns on their own based on for example, perhaps specific prices at low price points, or quantities, or location of seller, or use of your images, and then likely some of your own, the history of your own activities might be used by the automated system to do automated takedowns.
Great. Aaron, anything else, or?
No, not from my end.
All right, let's just jump into the teased bit of case law here. And so the piece of case law that's kind of in play right now is a seller and a patent holder of essentially a cell phone mount. And it's in process right now. This really wasn't part of the neutral evaluation program. They tried to get it into it. Amazon said no, thank you. But one of the attendees' earlier questions about this, is this a DJ action? And very much here it is. They were banned from selling their product to Amazon, so they took actions in their own hands and tried to get a declaratory judgment on the part of the seller to overcome this ban. Remains to be seen what's happening. It's in settlement hearings right now before magistrate. I'm sure that the current epidemic is probably going to slow that down a hair. But then, in the same breath, the patent holder did a counterclaim on the DJ action, saying that they actually do. And so the outcome here is probably a lot more expensive than both of these participants, anticipated. And so I think the world's wide open on what they can do on this as well. Francois, do you want to comment on any of this if you have a thought, or?
No, that was a great summary.
Okay, and anybody else? Otherwise, we will simply move on here. we're time check wise, we're coming close to the end of our presentation here because there's really not much more to cover here. So if anyone has questions, please start typing them in here. Otherwise, here we have them, and we can certainly begin to answer some of these as well. We have a question here as a former PTAB judge who wonders about the lack of sunshine here. With takedown GDRPs, there have been postings of notices and results that help the public. Is there anything here that Amazon or outside public data collectors is putting up? And I'll start the answer on that is, I've not seen anything, and I worked fairly diligently at getting an amount of trying to find whatever sunlight I could on this, and I have not seen anyone responding to that in that manner. So,
and I also think that it's going to be in violation of the confidentiality agreement that is in place, and I think as part of ADR, you want settlement through ADR should be encouraged and nurtured, and the confidentiality of ADR is one way that is facilitated. So I don't really think this is, at least based on the current structure, that is going to be published or otherwise quantified.
Yeah, I tend to agree with that. I don't. Since this is still a private company's actions, a private company with a lot of ability to move markets, I do think that there's going to be a limited number of people who can do as the case law did and file a DJ action, and to really give better numbers, I think is going to be slow and coming from Amazon. Aaron, Pam, do you have any other thoughts on this?
I don't have any other thoughts on this particular topic. I did have kind of a side thought going back to just participating in the program itself. We mentioned on Project Zero that it's invitation only, and that really your historical takedowns is a big piece of being invited to participate in that. I didn't see any information when I was reading up on this as to what process there is to be invited. Are you on a list? Do you get on a wait list? I mean, how is that process taken care of?
No, I don't have a good sense for that myself. I think you probably have to be, bothering Amazon quite a bit to directly to get the invitation. But Francois or Aaron, do you have a thought?
Well, I would probably imagine that if you have, as Pam said, some good brand registry experience with Amazon, you take it up with them and say, hey, we're good sellers, we're have great products, we're good, we behave well in our brand registry. Can we get an invite to the neutral patent evaluation?
So the good old vendors network.
Yeah, I was assuming that was it, but I wasn't positive.
Okay. And Aaron, any thoughts?
Yeah, I mean, I suspect that first you might need to file just a traditional takedown request with Amazon to even get on the list to be invited. But yeah, again, I haven't seen any actual published information on how you do get invited.
So in summary, any closing thoughts from everybody here? I mean, my summary is this is very much a work in process, and I think it will be more confusing, more than less confusing, at least over the next period of time here while they're sorting this thing out. Pam, how long did it take for the brand registry to settle down?
Oh gosh, a number of years, and then of course then in 2017 when more strict requirements were put in place, I think there was a lot of confusion, at least initially, about updating your information or getting your information up to date so that you could participate in it, and so I think that we're going to see the same thing here. I don't have a good sense though on how long this will take. Again, this is a more, in my opinion, a more complex process than you have with brand registry. So I would imagine we're going to see changes over the next several years.
Okay. Aaron, any closing thoughts here?
Yeah, against from a Chinese perspective, I think this is really powerful tool for against Chinese sellers. Oftentimes, Chinese sellers, their only or largest marketplace might be on Amazon. So by being blocked on Amazon, that's almost the same as filing a 337 action to block export from China. So this is, I think, an extremely powerful tool for PAN owners against foreign sellers.
Great. Well, I guess
my final comments are, I think that as with any enforcement, it's likely to be a bit of whack-a-mole. Someone you might get a certain Chinese seller's products removed, and then they might reappear under a different name or a different seller ID, and the part of we're never going to eliminate counterfeits and knockoffs, but if you make a nuisance of yourself as a seller, then maybe those sellers will go and knock someone else's products off. And my other comment is that this is still a pilot program. Amazon, if there's a backlash or Amazon decides it's too much work, I don't think it's out of the question that they might just shelve it as an experiment that they decided not to continue with.
Fantastic. Well, I think the consensus of the panel, if I may interpret it, is to be determined at this point, because I think as this gets more structure to it, this appears to be one of the many tools that one can deal IP enforcement with that Amazon is bringing forward. I encourage them to continue their innovation, if anyone is listening. But I do appreciate the time and attention everyone has had here. We've had an amazing attendance for this, and thank you for bearing with us. Any last questions? Just take a minute or two waiting for those, but the presentation will be made available, and I believe it will be up on the Schwegman webpage, or if you don't have it in there, so you can certainly see any one of us in the sorry, lost my train of thought here. You can see any of us on LinkedIn here or on the Schwegman Wedge page. You can see Francois, Pamela, Aaron. Oh, sorry, Aaron. I thought you were next. Then Aaron and myself. So other than that, please thank you for your participation, and please address us directly or indirectly as you see fit. Otherwise, thank you very much. I don't see any more questions coming in. Whoop, I've got one more question coming in. Thank you, everyone. All right, well, that's it. Thank you for your time. I appreciate everyone's attendance, and we'll see you very, very soon. Stay safe, be well. Bye-bye.